Welcome to The Explainer. I am so thrilled to have you with us today because we're looking at a story that is just as deeply human as it is legally profound. We're going to explore a massive landmark constitutional court case out of South Africa that completely fundamentally reshaped inheritance law. It's known as Bhe v. Magistrate Khayelitsha. If you've ever wondered how the law balances the heavyweight of ancient cultural traditions with the absolute non-negotiable necessity of modern human rights, you are going to find this incredibly fascinating. So let's get right into it.
Think about this for a second. How could a dusty, outdated law leave two innocent young girls completely homeless? To really grasp this, we have to look at the dire, real-world stakes for the Bhe family. We're talking about a woman named Miss Nonkululeko Bhe and her two minor daughters, Nonkululeko and Annalisa. After suffering a tragic loss, these two young girls were suddenly staring down the immediate threat of losing the only home they had ever known, and it was all because of a legal system that, well, effectively erased them from existence. Section 1. The threat of homelessness. The story actually starts in a temporary, informal shelter in Khayelitsha, where Miss B and her partner Vuyo lived with their two daughters, right up until Vuyo's tragic passing in 2002. Okay, let's dive into this. Because Vuyo died intestate, meaning simply he passed away without a valid will, he didn't leave behind a legal document saying exactly where his property should go. Now, normally when this happens, a state's default inheritance rules just kick in to make sure the immediate family is taken care of, right? But as you'll see, the default rules that applied to the Bhe family were anything but standard. Because of the highly specific laws applied to Black South Africans at the time, a local magistrate didn't give the property to Vuyo's partner or his young daughters. No way. Instead, the magistrate appointed Vuyo's father, the girl's grandfather, who lived miles and miles away in the Eastern Cape, as the sole representative and heir. And the grandfather made his intentions crystal clear from the start. He planned to sell the property in Khayelitsha to cover the funeral expenses. Just like that, Ms. Blomi and her two little girls are facing immediate eviction. Section 2. A racist legal legacy. So to understand how a family's home could just be handed over to a distant relative like that, we really have to zoom out and look at the deeply flawed, systemic, historical framework that allowed this injustice to happen in the first place. And this brilliantly illustrates the core of the problem. South Africa was actually operating under two completely parallel systems of inheritance. On one side, the Intestate Succession Act of 1987 applied to the general population and protected spouses and descendants. On the exact opposite side, you had Section 23 of the Black Administration Act of 1927. This was a parallel exclusionary system imposed specifically on Africans. It dictated that their estates absolutely had to devolve according to what the act called Black law and custom.
Justice Ngobo certainly didn't mince words about this, describing the Black Administration Act as an egregious apartheid law which anachronistically has survived our transition to a non-racial democracy. I mean, Section 23 of this act was deeply, overtly racist. It was originally crafted to fit perfectly into a system of racial segregation and oppression. By forcing African estates to devolve under the super rigid interpretation of customary law, the statute book basically maintained a painful relic of South Africa's hurtful past.
Section 3. The primogeniture problem. So what was the specific customary rule that was essentially weaponized against Miss Berbea's daughters? The main culprit here was male primogeniture. Simply put, this is the rule where the eldest male relative inherits the position and the property of the deceased family head. If a man died without a son, his father inherited. If the father was dead, it went further down the male line. Do you notice who is completely missing from this equation? Women. Under this strict rule, women, daughters, and children born outside of a marriage were categorically excluded from inheriting anything at all. The consequence of applying this rule in modern, urban settings was absolutely devastating. As the source material notes, women and children literally became legally and socially invisible. The official application of this rule meant women were essentially treated like perpetual minors. They always required the tutelage of a father, a husband, or some male heir. They were totally denied the basic right to own and control the very property they lived on and contributed to.
Section 4. Clashing with the Constitution. This is where things come to a climax. Mrs. B, alongside another applicant named Charlotte Shibi, absolutely refused to back down. They took this parallel regime straight to the Constitutional Court for a showdown.
They argued that this system blatantly violated three fundamental constitutional rights. First up, human dignity. Second, equality, because the law overtly discriminated based on race, gender, and birth status.
And third, children's rights. I mean, the system was literally stripping vulnerable children of their shelter and support simply because they happened to be female or born outside of a marriage.
The court recognized something incredibly profound here. Listen to this. The Constitution asserts dignity to contradict our past in which human dignity for Black South Africans was routinely and cruelly denied. Denying these women and children the right to own property wasn't just some minor administrative quirk, right? It was a direct affront to their intrinsic human worth. It essentially implied that women were just not fit or competent to administer property. Section 5, the ossification of custom. But we have to ask a really crucial nuance here. Was customary law actually always meant to be this inflexible and cruel? Was it meant to render extended families homeless?
Now, what's really interesting about this slide is that it breaks down the tragic difference between what the courts enforced and what communities actually practiced. Official customary law, the fossilized version captured in old colonial textbooks, was rigid and hyper-focused on male control. But living customary law, the way people actually lived their lives, was adaptive, dynamic, and focused on consensus and genuinely supporting the family.
The real tragedy, as the Constitutional Court pointed out, was that by capturing customary law in colonial legislation, the system was robbed of its inherent capacity to evolve. Society changed. People moved to urban areas like Khayelitsha. Nuclear families became way more common than massive extended families, and women became primary economic providers. But the official law in the statute books was totally fossilized, completely out of step with the living practices of communities where widows and the youngest children often naturally took over property just to survive.
Section 6, the landmark ruling. All right, armed with the Constitution, Deputy Chief Justice Longa delivered an ultimate resolution that altered the legal landscape forever.
Justice Longa delivered the first part of a totally devastating judicial remedy. Section 23 cannot escape the context in which it was conceived. It is overtly racist. And with that, the court struck down Section 23 of the Black Administration Act entirely. No more racially divided parallel inheritance systems. Gone. But they didn't stop there. They immediately followed up with a second massive blow. The court declared that the customary rule of male primogeniture, as applied to intestate succession, is completely unconstitutional. Justice Longa made it super clear. You simply cannot reconcile a rule that categorically excludes women and extramarital children from inheriting with a constitution built firmly on equality and human dignity.
So, what was the immediate, practical solution? The relief granted was that the Intestate Succession Act would now govern all estates, ensuring equal protection under the law for everyone across the board. For the Bhe family, this meant the magistrate's original, terrible decision was thrown right out. Miss Bhe's two minor daughters, Nonkululeko and Annalisa, were declared the sole legal heirs to their father's estate. Their home was safe, the exclusionary system that made them invisible was finally completely dismantled.
As we wrap up this explainer, I want to leave you with a provocative question to chew on. How do we balance respecting important cultural traditions with upholding universal human rights? The Bhe case shows us that while culture is undeniably important, it cannot be frozen in time, especially when that frozen version actively harms the most vulnerable among us. Laws and traditions must breathe, they must adapt, and above all, they must respect human dignity. Thank you so much for joining me on this deep dive, and keep asking the big questions.